Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah. Document Tingz, bringing truth to the light. Paper trail strong, yeah, we reading it right. From the docket to the drop, every case, every scene. I'm your courtroom reporter with the facts in between. Yeah.
Hey guys, how's it going? Welcome back to another video. Y'all come on in, have a seat, grab your drinks, grab your snacks, and pay attention so we can get into this read. We are here to have a conversation about the newly updated court filing coming out of Southern District of Florida. Demoree Hadley versus Desiree Perez. Now, this is a daughter versus mother lawsuit. Not only is Demoree Hadley suing her mother, she included ROC Nation, Iconic Creative, Daniel Barber, Natalie Anderson, Sig9, James Fondo, Stephen Caddy, Jessica Caddy, South Broward Hospital District, Odyssey Behavioral Healthcare, Lifeskills South Florida, Outpatient, Broward County Sheriff's Office, John Doe number 1, John Doe number 2, and Rachel Bernstein. Okay, so this particular court document is the Omnibus order on motions to dismiss. All right, now if you follow me on X, formerly known as Twitter, you will see that it was posted there first. All right, if you want to see it in real time whenever I post court documents before I actually come here on YouTube and read them, top left hand corner of your screen, as you can see there, that is my QR code. It will give you a direct link to my X, formerly known as Twitter page, and you can divulge in the conversation over there. Also, I have a plethora of other court documents that you can also divulge in at your leisure. All right, now before we actually get started, I want to make sure y'all see my copyright disclaimer under section 107 scrolling at the bottom of your screen. This is fair use. I am not a paralegal. I am not an attorney, and I am also not a judge. I am simply saying that, hey, I have common sense, and I also know how to read. Also, if you want to donate, that is my Cash App, Document Tingz. All right, so let's get that off the screen. And let's get into this court document. So I will be doing this video in segments, okay, just to give y'all a brief notion of what's going on. Judge Bloom issued an omnibus order on October the 8th of 2025, dismissing over a dozen claims, including RICO, negligence, and several IIED counts. Now, IIED stands for intentional infliction of emotional distress. Claims tied to civil conspiracy, false imprisonment, and federal wiretap violations will proceed against Desiree Perez, Barber, Sig9, and others. Claims against CTS Research, ROC Nation, Iconic, Anderson, the District, and Lifeskills were fully dismissed. Okay, so I just want to go ahead and get that out there. Again, I will be doing this video in segments. We're going to scroll down to page 15. Now, if you would like to read the entire court document here, it is 52 pages. I will have this linked in the description box below, or top left-hand corner, that's my QR code. You can go on my X, formerly known as Twitter page, and you can grab it there as well, whichever you prefer. Okay. Now, I want to go into each separate motion, all right, on each count. So I'm going to do separate videos on each count. Now, I'm going to start on page 15. Page 15 starts the counts, okay? As y'all can see here, we're going to start with the Medical Malpractice Act. So this is what we're going to start with. So if you see separate videos get posted about this particular lawsuit, I'm just going over each count separately, okay? So bear with me. Okay, so the Medical Malpractice Act, the district, Lifeskills, and Barber argue that dismissal is warranted because plaintiff failed to comply with the pre-suit notice requirements set forth in Chapter 766 of the Florida statutes. You can refer back to docket 149, 160, and 187. Now, I'm going to try to skip over those and just continue to read, but just to give y'all a generalization of what that means, okay? So I'm going to continue and just skip over those little quotations, okay? Plaintiff responds that the pre-suit notice requirements are inapplicable because her claims do not involve the rendering of medical care or services. Under Florida law, a claim for medical malpractice means a claim arising out of the rendering of or the failure to render medical care or services. Medical malpractice claims are subject to pre-suit screening requirements. Therefore, before filing a lawsuit, an attorney must perform a pre-suit investigation, consult and obtain an opinion from a medical expert, and provide proper notice to the prospective defendant. However, pre-suit notice requirements apply only to medical malpractice claims. It says the test to determine whether a claim is for medical malpractice is whether the claim relies on the application of the medical malpractice standard of care. When a claim relies on a different standard provided by another statute, the claim is not one of medical malpractice for purposes of the pre-suit requirements. Two cases are instructive. The court considered whether the pre-suit notice requirements were applicable where the plaintiff alleged that a physician group illegally used the Baker Act to commit plaintiff, had one of his doctors falsify the intake form, and wrongfully and intentionally prevented her from leaving the doctor's office. The court concluded that the facts did not involve the rendering of medical services because the plaintiff challenged the process by which she was committed and alleged that she was never actually evaluated. In contrast, and then y'all can see this is what they will be going over as we read along. You'll see the bloom and things of that nature, but let's continue. The plaintiff alleged that after an emergency room physician involuntarily committed the plaintiff, the hospital held her there against her will for 3 days, and hospital employees mistreated her in a variety of ways. The court concluded that the facts, as alleged, arose out of the purportedly improper mental health commitment that was based on the physician's medical diagnosis that the plaintiff met the criteria set forth in the Baker Act. Here, the court finds that the allegations against Barber are comparable to those alleged in King, whereas the facts alleged against the district in Lifeskills resemble those alleged in Bloom. The facts alleged here are similar to the plaintiff's allegations in King, where the doctor falsified the intake form to commit the plaintiff and wrongfully committed her. Here, the amended complaint asserts that Barber is institutionalized plaintiff under the Baker Act without any prior evaluation or examination whatsoever, wrote false information in the intake form to keep plaintiff detained, and conspired with Perez to have plaintiff admitted to Lifeskills. In contrast, the allegations pertaining to the district and Lifeskills arise out of the redemption of medical care. Indeed, and y'all can look at those counts right here, all involve plaintiff's detention at Memorial Hospital and Lifeskills facilities. The amended complaint does not challenge any actions of the staff while committed at the district of Lifeskills, other than the fact that she was wrongfully detained. For example, plaintiff does not allege that Barber or other hospital employees falsified her drug test or forms. Rather, plaintiff alleges that the hospital staff was clearly concerned about Barber's decision to detain plaintiff for involuntary examination, and unbiased professionals began to realize Demoree did not belong there. There are no facts alleged in the amended complaint as to either the district or Lifeskills that exceeded the scope of a typical medical malpractice claim. Therefore, the court finds that plaintiff was required to comply with the pre-suit notice requirements to assert claims against the district in Lifeskills, which she failed to do. Accordingly, the court dismisses counts, and y'all can see the counts right there, as to Lifeskills with prejudice. As to Barber, however, plaintiff was not required to provide pre-suit notice, and the court considers the merits of his motion. So there you have it there. That is for Medical Malpractice Act. All right. So the next video that you see, I will attach it at the end of this. It will be count 1, which will be RICO claim. We will go over this in a separate video. Now, if you like what you've seen here, like, share, and subscribe. It is all free. I appreciate y'all for getting me over 500 followers. We are on the road to 1,000. I appreciate everybody for sticking with me. And as I always say, when you lead with integrity, you never have to worry about somebody questioning your loyalty or your intentions. And with that being said, stay tuned because the next video is coming. See you soon.